Correct.
So what?
Oh, I'm looking at an old petition here. I'm sorry. This is old.
Yeah. Stuff all went to Schmidt. Oh, by the way, one more thing. Mr. Bastianelli, apparently you used the four-letter J word when you demanded a judge. Do you really want a jury?
But my client wants
that. Mr. Zilli, if Dad was a non-respondent before, he has a right to a jury. If his client wants a jury, we're going to do a jury trial.
Okay, that's fine. Yeah, I'm just trying to pull up the copy of the petition I had was from 2020, so that must have been old.
Pardon me? I am told that the mother's been terminated. I believe that the children are represented by JLSM. Mr. Zilli, Mr. Bastianelli, is that correct? JLSM represents the children?
I believe so. Let me check.
What case is it, Judge?
The
I wouldn't know.
Mara, Amir, and Daron. There's a Tamika Connor.
Looks like the LGAL at the prelim was Rodney Johnson.
Is he with JLSM?
It's hers. Yes, Judge, it's hers.
Okay. Tamika Connor has come in. Are you a worker for the Sanders children? Ms. Connor, you are muted on your end.
Yes. Yes, I am.
Okay. Which agency are you with, ma'am?
I'm the grandmother. I'm the foster parent.
All right. Are you caring for the children now?
Yes.
Okay. Are you the mother of the mother or the mother of the dad?
Dad.
Okay. The dad in this matter has asked for a jury trial on the subject of jurisdiction, and I'll get him that. I'm asked to terminate the dad's rights as a part of the petition. Mom, if something like Grandma, if something like that happens, do you want to continue caring for the children?
Correct. I would like to. If that happens, then I would like to adopt kids, my grandkids.
Now, Grandma, this can happen a bunch of different ways. The way that the Court of Appeals has told me they'd like this to happen is if you're a relative, become a guardian, become an adoptive parent. Do you have feelings?
I would love to. What's she?
Your Honor, we're a long way away from that. I can assure you, my client is going to fight these allegations tooth and nail.
Okay, but still, I like to get the thing I'm getting at, Mr. Bastianelli, is if Grandma is willing to be a guardian, the chances of me terminating parental rights are essentially zero, except if he's a sexual predator or a homicidal maniac. And you can talk with your client about that.
No problem. Perhaps we can set another pre-trial date.
Well,
before we set a jury. I haven't made any request to. This was just in prelim last week. Well, we had 3 prelims because of ICWA, and we were just authorized last week. I haven't had a chance to talk to Mr. Zilli directly in regard to any potential resolution or reduction, so perhaps another pretrial hearing would be best, Judge.
I was told that this was a permanent custody petition. Is that correct?
It is correct. That's correct.
Tooth and nail.
I can't get a copy of the petition. This bothers me.
Judge, I can
Could you
send you a copy of it.
zap me one?
This is the judge. Right here.
Mr. Bastianelli, what I typically do is a pretrial and then set a settlement conference about a month before the trial date.
Well, okay. I just need,
Ms. Pam,
I don't have a lot of time here.
the next time I have 3 days to put together for a child protection jury trial. This is Sanders. Also be ready with a date approximately a month before that for a settlement conference.
A month before that for a settlement,
Settlement conference.
3 days for jury.
Yes, ma'am. Everybody's ready to go on the record. Sounds like a yes silence.
Recording in progress.
Good morning. It's 11:01. I'm Christopher Dingle. I'm a Wayne County Circuit Court judge serving on the family court bench hearing juvenile matters. This is the date set for a pretrial on an original petition for permanent custody regarding the dad of the Sanders children, Amara, Amir, and Daron. The children are in the care of the paternal grandmother who is here. The children are represented by JLSM Affirmative Michelle Tillman. The mom's earlier been terminated. The dad was a non-respondent in the earlier action. The dad is obviously a respondent in this action. That's Daron Sanders, Sr. The dad has an attorney, Joseph Bastianelli, who's here. I have Assistant Attorney General Timothy Zilli here. I have a worker from DHHS. It is Tamika Connor. Did I get it right?
Yes.
We have Nicole Bowers, Your Honor. She's CPS. Miss McGee is foster care from Oakland Family Services. Is anyone else from foster care present? Or CPS? Okay.
Okay, Rayanne McGee, you are
She's foster
Oakland
care.
Family Services. Rayanne McGee. Very well. Nicole Bowers, you are a CPS investigator. Very good. And now then, and I have noted that there is a judge and a jury demand by Mr. Bastianelli. I'm going to do a pretrial today. To Dad Daron Sanders, did you receive a copy of the petition?
Yes.
Very good. Mr. Bastianelli, based on this, you'd agree I have good service?
Yes.
Very good. Do we have the presence of the necessary parties? Mr. Bastianelli, do you waive reading of the petition?
I do.
Dad, I've received a charging document. It's called a petition. It alleges that the three children, Amara, Amir, and Daron, are within the jurisdiction of the court. Jurisdiction is a $5 lawyer's word for the court having the power to order people to do things, and if they don't do these things, force them to do these things. Jurisdiction only exists when certain criteria are met. The criteria are listed in a statute. It has identifying numbers. It is MCL 712A.2. The relevant subsection is subsection B as in boy. If you look at it, there's 6 different types of situations where the juvenile is considered to be in sufficient danger to justify the court sticking its nose in everybody's business and spending a lot of money trying to fix problems of children and families. We're really only going to use the first 2 there, so don't pay any attention. Dad, if any of them, though, are satisfied, there is jurisdiction. If jurisdiction exists because of one of those being satisfied, the court is the juvenile is considered to be in danger. The court's supposed to do something about that danger. What the court does is called a disposition. The particular petition I have in front of me requires that I first consider a type of disposition that I don't like doing and is actually disfavored in the law, but under certain circumstances I'm required to do it. That type of disposition is one involving termination of your parental rights. Jurisdiction and the disposition are very much considered on a per child and per parent basis. The statute that covers terminations of parental rights is MCL 712A.19B as in boy. In order for the Assistant Attorney General to terminate and get me to terminate you, he has to prove two things within it. The first is that there's grounds for termination of parental rights. Those are listed in subsection 3. There are 13 or 14 of them there. He has to prove one. He may prove more than one. He has to prove at least one of them are in the child's best interest. He proves those things by the required levels of proof, then I must make parental rights. The best interest test is in subsection 5 of that statute. Now, the grounds that I mentioned earlier in subsection 3, they're well laid out in the statute. The best interest test in subsection 5 is not well laid out. There is not a list of factors in statute or in court decisions for me to look at. The best that I can offer you is something that the Supreme Court Administrator's Office drew up approximately a dozen years ago and then made a copy of it to every trial court judge in the state. They appear to have mailed a copy to every Court of Appeals judge in the state. The factors that they listed then were the opinion of experts, including psychologists and therapists, the caseworker, and the lawyer guardian ad litem, the likelihood of the child being adopted, the child's age, the child's wishes if of age, the child's relationships, extended relatives, whether the child has special needs, ethnic or cultural considerations, the length of time the child has been in foster care, and the bond that exists between siblings. In the time since the Supreme Court Administrator's Office sent me that memo, the Supreme Court has sent me a bunch of other memos that make it clear to me there's one more factor that the Supreme Court expects me to pay close attention to, and that is whether any of the children is in the first or second of the critical periods for brain development, the first of which is about age 3, toddlers. The second is early teens, puberty. Now then, if the Assistant Attorney General proves what he needs to by the required levels of proof, which I haven't gotten into yet, then I'm required to terminate your parental rights. If the Assistant Attorney General proves jurisdiction but does not prove what he needs to terminate your parental rights, then I would do a temporary custody disposition, which would involve things such as parenting classes and other services. Dad, do you understand this?
Yes, I do.
Very good. Dad, if I know Mr. Bastianelli, he's talked to you about various rights you have. The Supreme Court requires me to talk to you about these things also. First and foremost, you have a right to an attorney. Dad, an attorney advises you as to both legal and practical issues. If at any time you do not understand what's going on, please speak up. I will stop the proceedings and put you in a setting where you can talk privately to your attorney. Dad, do you understand this?
Yes.
Very good. Dad, in these matters, you have a right to a trial. This can be before just a judge or before a judge and jury. If there's a judge and jury, the jury will handle just the question of jurisdiction using those criteria listed in MCL 712A.2, subsection B as to whether the children are in danger. If the jury finds that there is jurisdiction based upon one or the other of those criteria being met, then the court will do a decision, not the jury. Dad, if there's no jury, then the judge will handle both jurisdiction and disposition. Dad, do you understand this?
Yes.
Excellent. Dad, in this matter, the Assistant Attorney General has a complicated series of burdens of proof. First, regarding jurisdiction. Regardless, it's the jury, the judge that's handling jurisdiction. The Assistant Attorney General has to prove that at least one of those jurisdictional criteria listed in MCL 712A.2, subsection B is satisfied. by a preponderance of the evidence, at least slightly more likely than not. If he succeeds in doing this, then the court has to do a disposition. If he fails to do that, then it's considered on a per parent and per child basis. It's considerably possible in a case where there's parents and multiple children, that children will be within the jurisdiction of the court regarding one, not regarding the other parent. Dad, do you understand this?
Yes.
Okay. Now, if there's disposition, the court has to do a disposition. The first type of disposition the court has to consider is one involving termination of your parental rights. This is disfavored in the law, and I don't like doing it, but under certain circumstances, I'm required to do it. The circumstances where I'm required to do it is if there's grounds to terminate parental rights. Those are in MCL 712A.19b, subsection 3. There are 13 or 14 of them. And the assistant attorney has to prove for the particular child or parent at least one of those by convincing evidence. Sometime a comedian's going to have a lot of fun because there's no clear definition to clear and convincing evidence. About the best that the Supreme Court, the Michigan legislature have come up with is to say that it's something between the criminal state beyond reasonable doubt. That's 95% of the weight of the evidence. And the preponderance standard that I just mentioned, a preponderance, 50%, that's a hair. What's in the middle of them, about 80%. That is about 80% of the needs. And for each child, each parent. In general, determination also has to prove termination of a particular parent of the child is in the interest to prove that preponderance of the evidence. If he succeeds in all things, then I'm required to terminate parental rights. He proves jurisdiction, fails is to terminate best interest, terminate a temporary disposition. There, that will include the parent. Dad, do you understand this?
Yes, I do.
Okay. Dad, in these matters, the assistant attorney has a complicated series of proof. Dad, I don't have a burden to prove anything. In these matters, I don't have insight. This is not only a civil matter. For example, a civil matter is breach of contract. In civil matters, you can be called as a witness against yourself. Do you understand this?
Yes. I do.
Excellent. Dad, if these things go to trial, the assistant attorney general is going to